There's a lot of confusion about benefits that are available for surviving family members after a veteran passes, especially in those sad situations where a veteran dies while their claim is still being decided or being appealed. And so can you talk a little bit about what substitution is in that context and how that works and what that means for surviving family members?
Sure. So here's how this works. For a very long time, when a veteran died, his benefits died with him. That was the end. Then Congress changed it to say that, well, a surviving spouse could get benefits for a period of time after the death.
Welcome to the Victory Over VA podcast, a podcast about empowering veterans to overcome denied disability claims. Each week, we deliver critical insights to help you understand the disability process, veterans' benefits, and how to take control of your legal rights. Now here's your host, Tony Francis Jackson.
Welcome to Victory Over VA, your guide to VA disability benefits. If you are a veteran applying for VA disability benefits, please subscribe to our podcast series to learn the latest developments in VA disability benefits. So welcome. I'm Francis Jackson. This is Christian Terrison, and we're from Jackson and MacNichol, a law firm that focuses on getting justice for veterans on their VA disability claims. So what is this all about? Well, today we're going to talk about benefits for those who are left behind when a veteran passes away. And who is this show for? Well, obviously it's for veterans, but more importantly, it's for those who support veterans, relatives, friends, or just those in the community who are supporting our veteran population. And so without anything further, let me turn it over to Mr. Terrison to get started on benefits for those left behind.
All right. Now we get a lot of questions and there's a lot of confusion about benefits that are available for surviving family members after a veteran passes, especially in those sad situations where a veteran dies while their claim is still being decided or being appealed. And so can you talk a little bit about what substitution is in that context and how that works and what that means for surviving family members?
Sure. So here's how this works. For a very long time, when a veteran died, his benefits died with him. That was the end. Then Congress changed it to say that, well, a surviving spouse could get benefits for a period of time after the death. And now the benefits availability, if you will, has been broadened. And what we are talking about typically is what's called substitution. And it just means what it says. A person is being substituted in the claims process for the veteran who has passed away. So the VA has a form. VA has a form for everything. So VA has a form for this, and it is a request for substitution. And in the form, you fill out and explain who the veteran was, when he or she died, and that there is a person who is eligible to be substituted on the claim and wishes to be substituted on the claim and is applying for substitution.
Okay. And does that mean, if the VA grants substitution and, there's a veteran who's, set for a hearing next month and they pass away, does the substituted family member show up at the hearing?
Well, typically not in that short a time frame. The way these usually work, in the scenario you've posited where a veteran has a claim pending that's going to the Board of Veterans' Appeals for hearing, most commonly what will happen is that the veteran dies, the VA gets notified of the death, and the VA then dismisses that pending appeal. When someone is substituted, they get to revive that appeal, and if it hasn't been heard, to have it scheduled for hearing. if the case was kind of further back in the process and it was a situation where there'd been a rating decision, but the veteran hadn't appealed it yet, but it was still within the 12-month window for appeal at the time that the veteran died, then what the VA does is they go from the date of the decision up to the date of the death. They count those days. They subtract those from the 1-year appeal period. And then when someone is substituted, they start that remaining period running. And as long as the person appeals within that remaining appeal time, then the case goes forward to a hearing.
And so it's very time sensitive. Is that fair to say?
Very time sensitive. And one thing that many survivors, particularly spouses, don't understand and are upset about when they find out is that this is not like Social Security. In a typical Social Security setting, if husband is getting Social Security if a husband is getting Social Security retirement benefits and he dies, then typically the wife would be eligible to get those ongoing benefits. She can't get them on top of her own, but in place of her own if the husbands are higher. VA doesn't work like that. The wife can't get the benefits the husband would have gotten in the sense of, he was getting a $3,000 a month check. She can't step in and get that $3,000 a month check. What the spouse can do if she's substituted on the claim is, number one, she can apply for any accrued benefits. And accrued benefits just means what it sounds like. It's benefits that have built up on a claim but have not yet been paid. So to take an easy hypothesis, say the veteran filed a claim in 2020, he died in 2024, the wife is substituted, the claim is granted in 2025, she would be entitled to get the benefits that would have been paid to the deceased husband from the time he filed the claim in 2020 up to the time of his death in 2024. And that's what the favorable decision from the VA will say when it comes out, that she gets the benefits from the time he filed the claim up until his death.
Now, you've mentioned in your examples spouses. Is anyone else eligible to substitute in these situations?
Sure. There are 3 other categories of people who can substitute. The obvious one is children. Children under the age of 18 can substitute. Children who are under 18 but going to school, as long as they meet the VA criterion for their school program and so on, they can apply and be substituted. And then what the VA calls helpless child, meaning a child who becomes permanently disabled and incapable of self-support before they reach the age of 18. To take a horrible example, a case where a 17-year-old is involved in a major car accident and brain damaged and is alive, but not able to support himself, that would be a helpless child, and a guardian or other appropriate person can bring the claim on his behalf and ask for ongoing benefits. Now, those folks would be eligible to apply for accrued benefits. The other group of people that can apply for this bucket of accrued benefits money are people who pay for expenses of the funeral and burial or expenses of last illness, at least to the extent of the money that they put into those expenses. The VA will, at a minimum, reimburse them out of the accrued amounts if the claim is later approved when they've been substituted and moving forward.
And from the timeline you were describing earlier, and as far as the appeal window, so really any attempt to substitute would have to happen within at least a year of the veteran's death, likely sooner?
That's correct. For accrued benefits, for any eligibility for accrued benefits, a claim has to be filed within 1 calendar year of the veteran's death. Now, what gets complicated is, say that the spouse gets substituted, makes the claim is going along, you're now at year 2.5 after the veteran dies, spouse dies. An eligible person can then be substituted for the now deceased spouse, but it just gets more and more complicated as you go down that line. but it can be done. The other thing that's important to know here is, in addition to accrued benefits, the VA has a category of benefits that they refer to as DIC, which is short for Dependency and Indemnity Compensation. And the purpose of dependency and indemnity compensation is to compensate the surviving family members for the loss of the spouse, the veteran, who the assumption underlying the statute was the breadwinner. That's not necessarily as true as it used to be, but regardless, that's the assumption underlying the law. So say that the veteran dies and you can show that his or her death was related to service. So take our example from earlier, the veteran who was exposed to Agent Orange and then dies of ischemic heart problems. That death would be service-connected because you can show that the death is ischemic heart disease and is presumptively caused by service in Vietnam, so service-connected death. When you have a service-connected death, the spouse, and again, children under 18, helpless children, children in school, can apply for these benefits and will receive a monthly payment. For a spouse, that monthly payment can go on for a lifetime. For a helpless child, it can go on for a lifetime. But typically for children, they will reach age 18 or 23, as the case may be, and age out, if you will, of those benefits. But there is a monthly stipend. It's currently, if I remember right, about $1,400 a month. I always have to look it up to be sure, but it's an ongoing monthly payment that would come to the spouse or the eligible children, and that would continue as long as their eligibility continues.
Okay. Now, can multiple surviving family members apply to try and substitute?
Yes. What the VA is supposed to do in those cases, they don't always get it right, but what they're supposed to do, if there are multiple surviving family members who qualify, they're supposed to create a class of survivors. And they will, if the claims are granted, they will divide the pot among the survivors. But the short answer is yes. You can have multiple eligible people, but they have to be at the same level. So if it's 2 kids under 18 and a helpless child, they would all qualify at the same level as dependent children, and the benefits would be evenly distributed over the 3 of them.
Okay. And what if an eligible family member is successful in substituting in, but then the claim is denied? What are their appeal options then?
Their appeal options are exactly the same as any other veteran. So if the claim is denied at the regional office, they can file a supplemental claim. They can file for a higher level review. They can appeal to the board. At the board, they have the 3 possible lanes: direct review, evidence submission, and hearing submission.
Okay. What are some of the most common mistakes you see when it comes to surviving family members and successful substitution claims?
Well, the most common ones I see are the ones that lead to unsuccessful substitution claims. And those typically are ones where there's a dispute within the family about who should proceed. Everybody's reluctant to get involved with lawyers and legal processes, and nobody gets around to actually making the application within a year. Those are the ones that are really sad, because sometimes there's a considerable amount of money that would have been distributed but for the fact that nobody got around to it within the 1-year window. Beyond that, the major mistakes that I see are same as mistakes on any other claim. People don't provide the VA with enough evidence. People don't stay in touch with the VA. There are various other procedural problems that get in the way of the claim getting favorably adjudicated. But, sometimes those claims really come out the way they should. A few years ago, before stomach cancer was presumptive, we had a lady whose husband died from stomach cancer, and we were able to persuade the board that, in fact, his stomach cancer was traceable to his exposure to Agent Orange, and she got several years of past DIC benefits. And one thing to note about DIC benefits, as I mentioned, accrued benefits, there's a 1-year cutoff. DIC benefits do not have a cutoff other than the eligibility of the applicant. So if a spouse misses the 1-year window for applying for accrued benefits, but still applies for DIC and is eligible for it, he or she can make that application years down the road. They won't get the benefits that they would have gotten had they applied in a more timely fashion, but they can get benefits.
And can, an eligible spouse pursue both substitution for accrued benefits and DIC sort of at the same time?
Absolutely.
There's no reason not to file both?
That's right. In fact, the form that the VA typically uses covers accrued benefits, DIC, and also entitlement to non-service-connected pension to the extent the widow may be eligible for that.
Okay. So for anybody who might be watching the podcast who thinks they may be an eligible, relative family member of a veteran who's just passed away, what would your first advice to them be?
My first bit of advice would be to contact the VA directly. Go, run, don't walk to the VA, and make sure that they know who you are and where you are and how to reach you, and put in a claim for any funeral or burial benefits that you might have paid for out of your pocket. My second piece of advice is to also file the claim. As I mentioned, there's a combined claim form that covers accrued benefits, DIC, and pension. Get that filed just as quickly as you can. And my third piece of advice would be get representation. It doesn't necessarily have to be an attorney. I like to think that our attorneys do a particularly good job, and that attorneys generally do a pretty good job with these cases, but you can also go with what the VA calls an accredited agent, a non-attorney who has passed a test and is allowed to help folks in this arena, or a veteran service officer from one of the many veteran service organizations, Disabled American Veterans, American Legion, Paralyzed Veterans of America, Vietnam Veterans of America, et cetera, et cetera. But get someone, because these DIC and accrued benefits cases get complicated.
I was going to say, I heard a rumor that you don't like to cut paychecks to attorneys who don't do a good job.
No.
Why would you keep them around? Anyway, thank you very much for tuning in. This has been another episode of Victory Over VA. Please be sure to subscribe and join us again next week.
We hope to see you then.
Thanks for joining us this week on the Victory Over VA podcast. Make sure to visit our website, veteransbenefits.com/podcast, where you can subscribe to the show in iTunes, Spotify, or via RSS, so you'll never miss a show. While you're at it, if you found value in this show, we'd appreciate a rating on iTunes, or if you'd simply tell a friend about the show, that would help us out too. If you like this show, you might want to check out our free consultation to see how we can help you with your denied claim. Simply go to veteransbenefits.com and fill out the form. You fought for us. Now let us fight for you. And be sure to tune in next week for our next episode.